In this video, we'll cover the UCC's concepts of course of performance, course of dealings, and usage of trade. To understand the relevance of these three concepts, we have to go back to the definition of an agreement under Article 2. As we have said, an agreement is defined as the parties' bargain in fact, what the parties actually agreed to. Well, how do we know what the parties agreed to? Note that the definition of agreement says that an agreement arises from two sources. Specifically, an agreement is the bargain of the parties in fact, as found in their language or inferred from other circumstances, including course of performance, course of dealings, or usage of trade. So the definition of an agreement suggests that an agreement arises from two sources. One is the express language the parties use to articulate the agreement, but the other is implied through course of performance, course of dealings, and usages of trade. So an agreement is based not just on the express words of the parties, but also on these three related but distinct concepts. Well, what are these three concepts, and what do they mean? As with any term used in the UCC or any other statute, the first place we should look is to the statute itself to ascertain what these terms mean. And in this case, all three concepts are defined in Article 1, Section 303. Remember, the provisions of Article 1 apply to all of the other articles of the UCC, including Article 2. Let's start with course of performance. A course of performance is defined under Article 1, Section 303 as a sequence of conduct between the parties to a particular transaction that exists if the agreement of the parties with respect to the transaction involves repeated occasions for performance by a party and the other party accepts the performance or acquiesces in it without objection. Stated differently, a course of performance relates to a pattern of conduct or interactions between the parties to a contract. Specifically, the pattern of conduct or interactions between the parties that occurred after the contract was formed, once the parties began their respective performance obligations under that contract. The most common scenario under Article 2 contracts are ones that involve installment contracts, where the parties' contract contemplates that seller will deliver goods to the buyer in multiple installments or lots. Any pattern of conduct or interaction in performance of that contract by either the buyer or the seller can establish a course of performance for future installments. Next, let's look at course of dealings. Course of dealings is defined as a sequence of conduct concerning previous transactions between the parties to a particular transaction that is fairly to be regarded as establishing a common basis of understanding for interpreting their expressions and other conduct. So, like a course of performance, a course of dealings relates to a pattern of conduct or interactions between the parties to a contract. But unlike course of performance, a course of dealings relates to the pattern of conduct between the parties before or prior to contract formation, namely any pattern of conduct between the parties that was established under any prior transactions or contracts between the parties. So if the parties to a contract have engaged in previous transactions, any pattern of conduct or interactions in connection with those previous transactions would establish a course of dealings for their present contract. Finally, usage of trade. Usage of trade is defined as any practice or method of dealing having such regularity of observance in a place, vocation, or trade as to justify an expectation that it will be observed with respect to the transaction in question. Unlike course of performance and course of dealings, usage of trade has nothing to do with the conduct of the parties to the contract. Instead, usage of trade is all about regular practices or lingo of a particular industry, custom that is so commonplace in that industry that we could reasonably expect the parties to this contract intended those customs to apply to their transaction. Indeed, I'll sometimes refer to these three concepts collectively as custom or customary terms, because these concepts all describe the customs and contexts in which parties to an agreement are operating. The idea being that the parties to an agreement would reasonably expect such custom to apply to their agreement. What is the importance of these three concepts? Article 1, Section 303 goes on to tell us in subsection D. Subsection D states two important rules. First, customary terms supplement or add to the express terms of the parties' agreement. So beyond the express words the parties use to articulate the terms of their agreement, customary terms are also a part of the parties' agreement. Thus 303E makes it possible for one party to argue that additional terms beyond the express terms of the parties' agreement are part of the parties' contractual obligation. They supplement or are in addition to the express terms of the parties' agreement. In addition, subsection E says that a course of performance or course of dealings between the parties or a usage of trade is relevant in ascertaining the meaning of the parties' agreement and to give particular meaning to specific terms of that agreement. Stated differently, customary terms may be used to help interpret the express terms of the parties' agreement, the terms the parties use to articulate their understanding. Where there is ambiguity in what the express terms mean, where the express terms are reasonably susceptible to more than one interpretation, custom may be used to ascertain the meaning of the agreement in general and to give special meaning to the specific words and terms the parties used in the agreement. Thus, it makes it possible for one party to argue for a more sophisticated understanding of the express terms of an agreement, an understanding that is not limited to the express words of the agreement, but also informed by the context in which the agreement was made. In addition to telling us the role that custom plays in the parties' agreement, Article 1, Section 303 likewise provides guidance on how custom interacts with the express terms of the parties' agreement. Specifically, subsection E says that if the express terms of the parties' agreement seem to be in conflict with applicable course of performance, course of dealings, or usage of trade, then, whenever it is reasonable to do so, the express words and custom must be construed in a manner that is consistent so that there is no conflict between the express terms or any course of performance, course of dealings, or usage of trade. But if there is no reasonable way to interpret the express terms of the parties' agreement consistently with applicable custom, if, for example, the parties' prior course of dealings simply conflicts with the express terms of the parties' agreement, then subsection E goes on to provide us a hierarchy or a rule of priority. Specifically, it says that if a consistent construction is unreasonable, then the express terms of the parties' agreement prevail over course of performance, course of dealing, and usage of trade, and course of performance prevails over course of dealings and usage of trade, and course of dealings prevails over usage of trade. Note you'll find a nearly identical version of this rule in Article 2, Section 208. The rationale for this hierarchy may seem pretty intuitive. That is, that the express words of the parties are the single best evidence of what the parties intended to be bound to, whereas a usage of trade, by contrast, has nothing to do with the specific parties to a particular transaction. Instead, trade usages are about what other parties in the same business or industry as the parties to this contract would have intended. So to summarize, in this video, we looked at how course of performance, course of dealings, and usage of trade may add to or supplement the express terms of an agreement, and therefore the resulting contract. In the next video, we'll look at another place where contract law, and in particular the UCC, supplements the express terms of the parties' agreement with the duty of good faith and fair dealing.